OKTA, which is the system that will authenticate them to get into the new system. And we're actually going to be going live with the new system within the course of the next 30 days. So again, it should not be any major impact for your folks once we can get them into the system. So again, this is something that's coming. You'll get, those of you that have login credentials for the coin system now, will get an email. We're gonna send you all an email first that tells you what this email is gonna look like and what you have to do with it when it comes. And then you'll get that email. You'll go in, you'll get yourself set up with the new system. And then probably around mid-May, we'll kind of cut you all off out of the system. We'll transition, we'll turn you all back on, and we'll be in a new system. It should be transparent. It's taken us a long time, actually much longer than it should have, to get the new kind of authentication portal, your new access set up. So as a result of that, we've had a lot of time to work out the bugs, and we're hopeful that we have most of them worked out of the new system. But they probably won't be any worse than the ones that are already there. We'll just have a better opportunity to fix those that are there. So again, nothing huge. Obviously, there are more changes we'd like to make the system better and more friendly and look at some policy implications, things like that. That's a little bit down the road given the timeline we had, but that is kind of a big change that's coming in the next month, and just kind of wanted to be able to let you all know that that was coming. Other than that, I just want to take a few minutes again to thank you for your patience. We've had a lot of staff transitions. I know some of you probably have too. It's hard to fill positions, it's hard to find people, and we've had a fair amount of transition in those direct support positions that you all deal with or that your staff deals with every day. And so I appreciate your patience. Brian and Donna were hired a little over a year ago. They've been learning a lot. I hope that they're helpful to you. If they aren't, certainly let me know. And I hope that you all will have the opportunity to meet them at a future one of these meetings. This is a really bad time. It's 2 days before the budgets go out, so they're pretty busy getting a lot of stuff ready, but hopefully we'll have the opportunity to bring them to one maybe in the fall to see you all. This does wrap up what I wanted to speak with. I'm happy to answer any questions that you all have, but I do thank you all for letting me be here today.
Any questions for Mr. Socio? Thank you, Robin, for being with us. And for those of you that maybe hadn't worked with Robin and her staff before, they are always available to answer your questions. Anytime we've called, they've been a tremendous help to us and worked through. I do have one question, Robin. Yesterday I got notice by email that we'll be losing 2 or 3 of the EC positions. And I tell you, I was feeling so good yesterday, I didn't open the rest of it. When does that take place?
I'm sorry, Mike.
That's okay. We'll talk. When does that take place?
July 1.
July 1. Okay, so we've got a little time to react to that and do what we can on the local side to try to keep those positions.
Yes.
Okay.
And if you have other vacancies, obviously we move those people over.
Okay. All right, any other questions for Robin? We really appreciate you taking your time and being here this morning. And I like the analogy, and I've heard the analogy of the pie before in years past. And I think Robin can attest to that. We're fortunate to have John Jones and his staff, and they're usually in the kitchen when the pie is being made. They don't wait for the pie to cook. That's one thing about the Sheriff Association and VSI. They're there way before the pie has been put together. And so it'd make a bigger pie. But again, thank you, Robin, for being with us. We appreciate your time. And now I'm going to ask Elizabeth and John to come up. That's fine.
Good morning again. So we want to spend the next few minutes talking about some of the bills that passed the General Assembly and the process that we use when we were dealing with the pie that Robin was talking about. And our presentation is in the app. You can go through and look at that, or you can just follow along with what we're talking about. Let me tell you a little bit about how we do this in the Sheriff's Association and how our legislative priorities are established. Each year, the President appoints a legislative committee, which is 8 sheriffs and the chairman, and the board of directors of the VSA also serves on the legislative committee. So we have about 25 sheriffs that serve on the legislative committee, and a list of those sheriffs is in the packet. So the legislative committee will meet usually in November, early November after the election, and they'll decide on what they want the association to do, and they'll vote on it. We'll send it out to you all, and you get an idea that we're looking at funding the 1 to 1,500 or the pay raises or whatever it might be. And we go and we get patrons for all of our bills. We get patrons for our budget amendments, and we get those budget amendments and patrons introduced. The budget amendments during the first week of the session, and they're very close deadlines, and the bills introduced earlier if possible. So the role of the legislative committee is to review all these bills that come up. And let's see, I need to hit, there you go. So this is just a picture. The legislative committee looked at 111 bills this year. And we have a system in our office where the committee will look at it, it'll show up on our app, and they'll tell us whether we like it or we don't like it. And then the ones that we like, we work on them and we prioritize them. We try to get those passed. The ones we don't like, we prioritize those and try to kill the really bad ones. So the notebook and the presentation that you're going to get includes bills that were in the General Assembly prior to adjournment, signed and died. Does not reflect any actions taken by the governor or actions in the veto session. And those will be published on July 1st when they come out. But most of the bills we're going to talk about are in a final state. But when you go back home, don't use this document. Go and look the bill up, because there could be a minor change that's meaningful. So use this as a guide only. I want to talk a little bit about the budget. Robin's already talked about the details of it, but you need to know about some of the things that happened in the budget. And we'll first talk about the House budget. And you know, when we looked at, the first dot is the sheriff's salaries. For the last 2 years, we put in budget amendments that would give the sheriffs an across-the-board $10,000 raise. One of the amendments gave the sheriffs an across-the-board $25,000 raise. Some sheriffs are making less than state troopers. And some sheriffs even objected to that, saying, you know, the priority is not sheriffs. Those bills didn't pass. They didn't really have the support of the VSA, and they really weren't voted on by the legislative committee. I heard from sheriffs and went ahead and put the amendments in hopes that we would get something and get those salaries up. In previous years, that didn't happen. So this year, we took it to the legislative committee with a little bit of a new idea, and the argument when we went in with the across-the-board raise, some of the higher population sheriff salaries are already up, because if you have a sheriff, say 10 years ago, that was making $100,000, and over the years you get the percentage increases, that goes up a lot more than the sheriff that was making 70, and you get the percentage increases. 5% of 70 is less than 5% of 100. So there's been a disparity created, and it's extended over years. So what we decided to do, and the legislative committee voted on this, and that made a huge difference, was to take those population brackets, all the ones below 70,000, and bring them all up. You have, instead of having 0 to 10, 10 to 20, 20 to 40, and 40 to 70, you now have 0 to 70. So then we go out to the General Assembly and get legislators to introduce those bills. And let me tell you who put them in. Delegate Emily Brewer put it in. Delegate Hodges put it in. Delegate Don Scott from Portsmouth, and he doesn't even have a sheriff that will benefit from it, but he put it in for the association, and Delegate Wren Williams. I don't think I missed any. of the House members. And then in the Senate, we got Senator Stewart and Senator Linwood Lewis to put it in, and Senator Stanley always put it in. So these amendments are moving forward. We're going to the key legislators and explaining what I just explained, that these sheriffs in these lower brackets really need a raise. It resonated in the House, and the House put the money in, $1.4 million. In the Senate, it got delayed. It got off track. And let me tell you what happened with it. There was a study resolution. There were 2 study resolutions put in about sheriffs, and we went out and killed one of them, because when you're asking for a study, you don't get money, you get the study. And we killed it, and we got a little pushback from sheriffs that didn't know why we did it, and after I explained it, I think most of them got it. But there was another study resolution put in, 239, was put in by Senator Hackworth, who is a close friend of the association, but some of his sheriffs, I think, others, asked him to put the study resolution in to study how the comp board does at 1 to 1,500. Well, you just heard from Robin what they're doing. They're doing all they can do. It's not about changing it. It's about putting money up and funding the 1 to 1,500. There's not a lot that need to be studied, but the resolution said the comp board would look at other ways to do that. Well, that study resolution passed the Senate. We thought it was harmless. It wasn't. It gets over in the House, and it's moving through, and the Senate budget comes out on the sheriff's pay raises. And let me tell you what the Senate did. Instead of giving the sheriffs the pay raise of 0 to 70, they said the language amendment directs the comp board to include the study pursuant to Senate Joint Resolution 239. This is talking about the pay raise for sheriffs. An analysis in feasibility and fiscal impact of adjusting the population brackets. So we got our fear. You put a study resolution in, you got the study, you didn't get the money in the Senate. We didn't know that had happened, still thinking that the study resolution was a good idea. Fortunately, Speaker Todd Gilbert didn't think it was a good idea, and his House killed the Senate study resolution. So when the study resolution goes into the Senate, it had a bad impact on our amendment. It basically killed it. The Speaker killed the Senate resolution. He's the chairman of the rules, and that's where they go. He killed it. And now, so you have no study resolution. What I'm hoping for, and we're working really hard. I met with Chairman Knight last week. Since the Senate said, well, let's study it pursuant to this resolution, now the resolution's dead, we're hoping that the House version will pass if we get a budget. So that's where that is, and everyone needed to know the story on that. The 5% salary Robin has already discussed. There's $14 million in both sides on compression. It's not just $100. She talked a little bit about that. And she mentioned the $4 million for transportation of TDOs and ECOs. Elizabeth and I met with Chairman Knight on that last week. The House stuck with us on it, leaving the money with the comp board for sheriffs. The Senate moved it and put it with DBHDS for contracts. Well, if you do that, we're not going to get it all. The police will be getting it under contracts, and there's a problem with some of those contracts, in my opinion. So we're advocating leave the money with the House. The police got $599 money. They can use it for that. So I'm hopeful we'll get that $4 million back. Now, the Senate budget has already been discussed. It's pretty much the same. It's what Robin said. I'm being told, and just, I don't know what's going to happen with the Senate budget, but I think the strategy is that we're not going to get a budget until after the primaries. Because you've got Democrats being pushed from the left saying that their opponents in the primary are saying, you don't want to give the governor anything. We want to spend money on programs. We don't want to give it back in the form of tax cuts. You've got Republicans being pushed from the right saying, we don't want to give the Democrats anything. We want to stick with the governor's plan. We don't want to give it in programs. So on both sides, you've got that going on before primaries. The way I think, and this is just John's opinion, the way I think they're going to deal with it is not deal with your budget until after the primaries. So whatever happens won't affect either side. And I don't know that's what's going to happen. We could get it tomorrow, we could get it at the end of June, or we couldn't get it. Or we may not get it, but I think it'll come at the end of June, but there's no promise, nothing to take to the bank. So now, mental health. Now, Elizabeth is going to take mental health. Excuse me, do you have any questions? You can interrupt us, this is a little bit informal, but if you have any questions, just raise your hand.
So mental health transportation is pretty top of mind for, I think, everybody in the room. The tricky part about the mental health transportation is that law enforcement, sheriffs hold the burden of it not working, but we don't really have a stake in making it work well. We need other entities and other people to make the changes so that law enforcement is not burdened. So when we embarked on finding solutions, we looked at pieces on the edge, if you will, that could kind of trickle down to relieve some of the burden on law enforcement for this lengthy period of custody when you serve and pull somebody into custody between their entry into the treatment system, which is obviously the main problem. So first on that, it was brought to my attention by quite a number of sheriffs that we have a pretty substantial population of intoxicated individuals who are subject to ECO and TDO, and yet they're being held, and over the course of time, maybe their intoxication wanes, but they are still under the ECO and TDO, still requiring law enforcement custody, still extending for hours and hours and days and days. So I drafted a bill that would make it easier for ER doctors to get a medical TDO, which was a provision already in the code. In many of our work group meetings with multiple stakeholders last year, it was brought to our attention that the ER doctors don't seek them because it's really difficult to find a general district court judge. And they can do it over the phone and via video, but they can't put their hands on a general district court judge, which in my experience in the court systems is understandable. So I drafted a bill that made it easier for them to go directly to the magistrate, didn't need to stop by a general district court judge. So this is, again, something that we can't, you can't make the ER doctor do it, and you can't seek a medical TDO yourself, but I would encourage you to train your deputies to be thinking about intoxication, to be pushing or asking the ER physicians to maybe make that assessment to see if your person is intoxicated. They will need information from you about whether you had drugs near them when you put them into custody. Certainly, if you know of any other factors that they can relay to the magistrate to persuade the magistrate this is an intoxication situation. The reason why this benefits you is that a medical TDO does not require custody by law enforcement. So if an ER physician gets a medical TDO, the person can remain at the hospital without you for up to 24 hours. It may be at the end of 24 hours, intoxication symptoms wane, and they no longer need so-called mental health treatment, and they can be released. Or it may be that it turns out they do have a mental illness that is causing them to need hospitalization, and you would be summoned back to serve a TDO. But at least gives you that 24-hour period. DBHDS has suggested that at least 20% of people under TDO are intoxicated. So if we can encourage ER physicians to get medical TDOs for 20% of the TDOs that you're holding, and do a medical TDO, which doesn't require you to hold them in custody, I think it makes a real dent in the problem. That passed. It was a bipartisan effort. We had Delegate Ranson and Senator Deeds and Senator Favola put the bill in, and it did pass. So again, please encourage your ER docs to access this change July 1. 3 other bills that we worked with and supported. 1976-1299, House and Senate bipartisan bill from Delegate Rob Bell and Senator Cree Deeds. This is also potentially helpful. Again, you're not in control of how it works, but law enforcement has the real benefit here when it does work. This bill allows the director of the facility, so if your person is at a hospital, at the ER, you're holding them in custody, waiting for the state facility or some other facility to find a bed. If they no longer seem to need hospitalization, maybe their symptoms have changed or they become stable with the treatment in the ER or simply time has passed, the director of that facility can ask the CSB to do a new evaluation to release the person from the TDO prior to them receiving treatment at the temporary detention facility. Again, you're not in control of that, but it does benefit law enforcement when it works. SB 827 from Senator Favola is a hospital bill, but in that bill, it requires emergency rooms to hire off-duty law enforcement for security based on their security needs, and that, again, has the potential to benefit that there might be, over time, someone to help alleviate some of the chaos and the security issues and the potential custody issues with ECOs. SB 872 is Senator Newman's bill, and it's a little tweak to the alternative transportation. It makes it a requirement. Up till now, it has been that they have to consider, but the magistrate does not have to order alternative transportation. And this little tweak requires, if alternative transportation is available, they must use it. And it also allows alternative transportation services to use restraints where necessary and appropriate. And that should increase the number of circumstances under which alternative transportation is used, because right now their contract services with DBHDS say that they can only use the very peaceful patients that don't require any sort of hands-on work or any sort of restraints, which is a pretty small portion of your ECO TDOs. Any questions about those bills? So moving on, the Legislative Committee voted last year and this year to support efforts to repeal some of the so-called criminal justice reforms that came down in the previous 2020 session and prior. And there has been not a significant appetite to undo those efforts, certainly in the Democratic-controlled Senate. There were a number of bills put into none of them passed. A number of bills were put in by Republicans in the House to repeal the bills preventing you from stopping folks for primary offense, and those passed the House, and they all swiftly died in the Senate. And I expect that to continue while the Democrats are in control of the Senate. We had only one bill that's interesting, if you will, on the service of process. That is SB 1089 from Senator Eben. It doesn't really have a significant impact on what you're doing. It requires that you return executed writs of eviction to the clerk's office, which you were probably already doing. There are a number of jail bills. There were, this first bill, HB 1524 and SB 820, was a collaborative effort from a number of stakeholders, Delegate Coyner, Republican in the House, and Senator Favola, Democrat in the Senate, as well as a variety of other entities. We all gathered together to discuss creating a fund to give to local jails to create programs for drug treatment, substance abuse disorder treatment, including medical-assisted treatment. And that was a focus, but it isn't the exclusive way that you can use the funds. I ultimately wrote the bill that was introduced and passed in a bipartisan way in both houses. It is unfunded this year, and it goes into effect next year in the hopes that perhaps in the next budget cycle, there will be money in the fund to actually send to local jails, excuse me. HB 2020 and SB 1073, that is a jail bill that originally was restricting drones flying over jails, and it had a boundary of 400 lateral feet that was prohibiting drones from flying over jails and juvenile facilities. And there was a significant objection to that from folks like Amazon, because they didn't want to redirect their delivery drones around jails. So the bill that ultimately passed prohibits drones that are flying over from dropping items or taking photos that would identify in any way an inmate. HB 2438 and SB 797 from Delegate Ellen Campbell in the House and Senator Favola in the Senate increases the membership of the state board, not your local jail board, but the state board, to require that one sheriff and one superintendent, as well as a mental health professional, be on the board. Right now, it is a sheriff or a superintendent, and I think it only has one mental health worker. Now it has two mental health workers, as well as the sheriff and a superintendent. SB 887 from Senator Morrissey and then Republican Glenn Davis in the House also put this bill in. This is up here not because it applies to you, but because it is a move towards what I think may trickle to local jails, that it's a substantial limitation on restorative housing, which is the DOC term for solitary confinement. And it doesn't impact local jails at this point, but it's something that I think is going to pop up next year or the year after, sometime in the fairly near future, as it moves throughout correctional facilities. John's going to talk about a couple of failed bills.
I want to touch base on Senate Bill 1379 was put in by Senator Deeds, and it started off removing sovereign immunity from almost all public, all of us. We fought it, and in the committee it got narrowed down to only apply to doctors. So we removed sovereign immunity from doctors in jails. So, and I mentioned it yesterday was when Senator Peterson was here. So we hear, you know, Senator Peterson talking about it, and I called my senator from Accomack, Senator Lewis, who's usually a dependable vote on reasonable issues like this. We were able to pull 2 votes from the Democrats over to the Republicans, which made it a potential 2020 tie. We called the Lieutenant Governor and said, here's a tie alert coming up. Get ready. We want you to vote with the sheriffs. It came up 2020, and she voted with us. So that was important, and it was revealing a lot of reasons on who our friends are. The other bill, Senate Bill 889, is Senator Morris's bill, eliminated jail fees. It was a fight last year. It was a fight this year. That was a study. That was a sham. They did a study. They asked us to send you to help. We asked us to ask you to do these voluminous surveys, and you know you got them. You had to put in 5 years of contracts with your vendors, and so the advocates, the ACLU wrote the report. Elizabeth and I sat at the table, and all these other people. Joe Barron, we owe Joe Barron a lot. I mean, he sat there and fought like a tiger and gained a little bit of ground, but at the end of the day, it was a total sham. The surveys that you sent in, I never saw them. Nobody saw them. We wanted to know, we put it in a survey, how much money you're raising from fees, what programs you're doing with the fees, and what will happen to the programs for the inmates if the fees go away. So that would show the General Assembly, what, if you want to do it, here's going to be the impact. None of that was revealed in this study. It got put away, and the ACLU basically ran the study for the state, local, and regional jail board, and for Senator Marcy, who chaired it. So going into it, you know, the ACLU and all of them are standing up there showing the General Assembly they claimed it was the responses from the sheriffs. It was a redacted contract from a contractor. We never saw the responses. Long story short, we killed the bill in both houses. It went in the House. It was a version, I believe it went in the House. But anyway, it died, and it's coming back. So my message is we're going to probably have to take a look at these. And we seriously made a good faith effort to look at it, and if there are jails out there that are charging excessive fees, that's what's causing us a problem. Most sheriffs don't, from what I've seen, don't charge excessive fees. But there may be some, and I've heard stories of it, but we asked for it in the surveys, and we never saw the surveys. So get ready for it. You know, it's coming back, and it'll be probably back next year. Election to matter. I know Senator Marcy has opposition in the primary. So we'll see what happens with all of that. Now Elizabeth will back up.
I'm going to run through some bills that affect your essentially administration duties. I'm not going to talk about all of them. All of our past bills are in your app with a link to the actual legislative services. So when you click on that, you should have the most up-to-date final version. It's what's the system run by the General Assembly that should be in your app. I'm just going to highlight 3 on this page for time. HB 2007 from Delegate Rome, that is interesting because it requires your FOIA fee policy to be posted publicly, detailing how the fees are calculated. So that's a change that you'll want to put on your website if you've got that FOIA stuff posted on your website, which you should. You have to go through how your fees are calculated and what the fees for a particular request are. And that has to be publicly posted. HB 2150 from Delegate Delaney is a shift in the evidence kits. Right now, we've got PERC kits that are part of a series of statutes. And there are a lot of obligations about storage for that. So this adds trace evidence kits, which is for strangulation, that adds it into the code. You do not have the same storage obligations for the trace evidence kits, which are the strangulation kits, but you do have collection obligations. So if a victim elects to report to law enforcement, then the hospital has to notify you that there's a kit and you have to go get it. You do not have to submit it to DFS. You can if you think it's helpful. And there is not the same 10-year storage requirement that you have for the PERC. And then HB 2221 is from Delegate Hayes. Right now, there are a number of things that you can do by two-way video with your inmates in General District Court, and this adds conducting a waiver of preliminary hearing. So that's helpful that you don't have to transport people to court for that, but it creates a little bit of a paperwork situation that you'll need to solve with your courts and your Commonwealth's attorneys, because the defendant is required and his counsel are required to sign the back of the warrant to waive preliminary hearing. So that's a piece of paper that you have to get back and forth with the signature of the defendant and then send it back to your clerk's office. Happy to answer any questions from this page. There are 2 failed bills that I wanted to bring to your attention. Delegate Mullins put in a bill to require the release of law enforcement disciplinary files. It was very lengthy and detailed and invasive and completely and wildly objectionable. And I did object, and it did fail. The other is from Delegate Ware and a study of the Compensation Board, and John is going to chat about that briefly.
Very quickly, this was put in to study the Compensation Board, and we opposed the bill. We sent it out. The Compensation Board, over the years, we're enjoying more money right now. The budgets are improving. And now there are folks that say, well, let's take another look at the way we do the Compensation Board. Maybe they're not giving me what I want. Maybe this, or maybe we need another formula, whatever it may be. Maybe we need something like block grants. And it's easy to say that, but the Compensation Board is our advocate, and we don't want to participate in any study that's going to limit or abolish the Compensation Board, and that's where this kind of thing could lead. So I went to Delegate Ware and talked to him. First of all, he took us out of the study, which was fine, and then when the committee got it, Speaker Gilbert, in rules, when they got it, they killed the whole bill. And this was the one I was talking about. Some sheriffs called them and said, why are you killing us? We're killing it because it was a bad resolution, and there was a reason to kill it. And so we think when you do studies, you lose money.
So Sheriff's Office employment concerns. Just briefly, there were 4 bills that have impact on employment. The first one including anxiety and depressive disorder in your workers' compensation. PTSD is already in there, and it adds anxiety and depressive disorder for workers' compensation coverage. From Eileen Fillercorn, she put in a bill and it passed to increase the monthly health insurance credits received by retired sheriff's employees. That's the amount of money you get to offset your premiums for health insurance after you retire, and it was a pretty significant increase. SB 1107 from Senator Cosgrove reduces the amount of time for a required break in service for law enforcement officers to return to work as a school security officer and still receive a pension. Senator Norment put in a study to review and analyze options for post-retirement return to work. So you can double dip. Criminal code and enforcement, impacting your investigative function. We have just a couple to start. HB 1416, Delegate Brewer put in a bill that is a pretty substantial bill allowing for testing of STDs of defendants when the victim or witness, says that there's a reason to. They can either ask for it and the Commonwealth's attorney has to request it, or based on the conversation, the Commonwealth's attorney may request. And the testing comes either with consent of the defendant or after there's been a preliminary hearing, essentially to determine probable cause. So there are lots of protections for the defendant in a non-consensual testing, but it gives some protections for your victim who has been a victim of sexual assault or other means to have the defendant's bodily fluid potentially infecting the victim. So this is a good victim bill. HB 1995 from Delegate Krizik is a little bill, but it increases the amount of time to issue a summons for illegally passing a school bus. This is significant if you've got a camera system, an automated system. Right now, you have 10 days to issue a summons. Your automated system does. This increases it to 30 days. 2032 from Jackie Glass. Shannon Dion did not discuss it yesterday from the Victim Injury Fund, but this is a bill that goes into effect July 1, and it changes the eligibility for criminal injury compensation fund funds to your victims and witnesses. Right now, it stands that if a victim or witness is uncooperative, they don't get any money. The original bill from Jackie Glass said they get money whether they're uncooperative or not. And with some advocacy from me and from the Prosecutors Association, she changed the language to say that they could be uncooperative if law enforcement, you certify that either there were no services offered or there was a good reason, a good faith basis for their lack of cooperation, that there was an actual fear of retaliation or some substantive reason. Without that, there's a pretty good likelihood of making a police report, refusing to cooperate, and then getting money for your injuries. But we saved that. Two failed bills from Delegate Glass that are interesting just because they continue to come up, and they may come up again in the future from either this delegate or another. One created a presumption that an interview of a juvenile suspect was involuntary, no matter what the circumstances, no matter how old or how many times the juvenile had been arrested or interviewed before. The other from Delegate Glass precluded law enforcement from lying to a juvenile during an interview or using inauthentic documents or evidence, which is, I don't know, pretty much the most helpful thing you do in an interrogation. And I think there are probably plenty of juveniles who have enough fortitude and experience to resist that if need be. Those failed, thank goodness. School bills. Delegate Greenhall put in a bill to expand the school resource officer grant program to include funding for school security officers, as well as relevant school safety personnel. That's not further defined. And then also equipment, so it's not just for funding for your SROs. Senator Survell put in a bill that addresses a situation that was in the paper from Chesterfield Police Department, having notified that they had arrested a fellow for a sex offender registry crime, notified Fairfax County where he was employed by their school system, and it apparently fell on deaf ears. There was some difficulty in email addresses and whether anybody was checking an email or whether the email address had been updated. So Chesterfield PD did what they were supposed to do, but it the information never got where it was supposed to go, which caused a registered sex offender to be employed in Fairfax County Public Schools. This bill fixes that. It's a voluminous bill with lots of obligations for the school system. It, in short, requires them to have a really formalized process, to have a designee on an annual basis to receive the notifications. So there will be a central repository for the information for every school district across the state that you can access to find out who you should send the information to when you arrest somebody that requires this notice. Interesting part of that bill is that if you have VEC access already as a part of your law enforcement division, that you are required to use your VEC access to discover where the person is employed if you have arrested somebody for a sex offender registry offense. SB 1359 from Senator Normant requires new threat assessment team members to be trained, and that can include your law enforcement member of the threat assessment team and a refresher training every 3 years. One more training obligation. Some changes to the criminal code. There are kind of some interesting changes this session. Not interesting like they were interesting in 2020. From Delegate Sullivan and Senator McPike, they put in a bill that changes the definition of your annoying phone calls to include other devices. So not just phones, any communication device, not just ringing, but any sort of signaling. So that covers pretty much all of the electronic devices. Delegate Bloxham and Senator Hanger put in a bill to clean up the farm use placard bill that Delegate Bloxham put in last year. So last year it was a very pro-law enforcement, requiring, rather than just scribbling on cardboard or getting it from Walmart, your farm use placard, it required that people who had a farm use exemption go to DMV and get a number and a registration so that when you look at a farm use tag, you have something to look up so you know who is entitled to have it, who is driving it, that you can use it for law enforcement purpose. The farmers were really unhappy. So I think accidentally that farm use placard bill looped in all of their farm machinery, seasonal tractor trailers that may carry hay. They're literal actual tractors that they may drive on the road that you know are clearly farm use because they're tractors. And so this bill cleans up some of that language, makes it really specific to what types of vehicles have the exemption and what types of vehicles need the placard. It limits the information that DMV can get from the farmers, limits to whom they can disseminate that information to. Certainly, it still includes law enforcement. Clarifies that the vehicles are limited to pickup and panel trucks, SUVs, trailers, and semi-trailers, and other vehicles over 7,500 pounds that are able to use that farm use tag. Still can't use the Walmart tag. And it's a big, very long, lengthy bill. We will put something out in dispatch from the Farm Bureau that gives a little bit more detail. I'm always happy to answer any questions about that or any other bill. The HB 2166 and SB 896 from Delegate Williams and Senator McDougal added petty larceny to the list of racketeering offenses. There were a number of efforts to try to address the organized retail theft. I don't know if it's statewide or not, but it certainly is in more heavily populated areas where there are groups of people who are going and doing repeated petty larcenies from places like Target and Walmart, and then fencing the items, and it's a very widespread organized effort. But it's still petty larceny, which is, these days practically legal. We've had a lot of bills that passed that allow law enforcement to stop and investigate and penalize people for these individual petty larcenies by looping them together. So racketeering essentially is a ongoing offense. So this particular bill allows for conspiring and working together for over a period of time for anything that amounts to over $10,000. So your series of petty larcenies have to amount to ultimately over $10,000 to fall under these new racketeering bills. SB 1367, Senator Vogel, is kind of a standalone bill. It's independent activities of a child, so being left alone or allowed to walk to school or that type of thing is not necessarily child neglect, not necessarily a crime, depending on the individual circumstances and skills and abilities of the child. More changes. And this is a bill from Delegate Ballard and Senator McDougal that increases the number of predicate acts for criminal street gang, and a bill that increases every penalty for every aspect of the criminal street gang. So everything that was a Class 4 felony is now a Class 3 felony. Everything that's a Class 6 is now Class 5. So all the penalties are increased. There's quite a few additional crimes that constitute a predicate act for the criminal street gang series of crimes. From Delegate Wyatt and Senator Reeves, there was a change in the definition of weapon of terrorism to include fentanyl. So that bill was originally created to be kind of a traditional weapon of that statute was intended to be originally a classic weapon of terrorism, or back, close to 2001 when we had anthrax or something of that sort. And it's now been redefined to include fentanyl. It adds an additional crime if you knowingly distribute fentanyl. Not that you distribute drugs knowingly and it contains fentanyl, but you know that the drug packet contains fentanyl. It is an additional crime that you can charge in addition to your possession with intent to distribute or your distribution. 1892 from Delegate Ballard stems from a Giles County case in which a woman abducted a child not to do something additionally evil, but so that she could have a child. She was going to keep the child and raise it. And so that, prior to this bill, was simply a max 10-year penalty, and that's just not enough. And so Delegate Ballard put in this bill that says any abduction of a minor is now a Class 2 felony, which is 20 to life. Delegate Ware put in a bill eliminating switchblade from the definition of concealed weapon and adding stiletto knife. Senator Marsden put in a bill that increases the move-over law currently for emergency vehicles and those with amber lights to be any vehicle if the vehicle is displaying hazards or any other caution insignia. Two failed bills from Delegate Watts. I mention this one because it is definitely a trend, and I think will be even more so after what we see in the news from the use of force with people who were under ECO or under TDO and the consequences. We've had a recent death of a person who was under use of force after being ECO'd and then arrested for assault on law enforcement while under an ECO and then sent to jail. So this bill says that precluded charging a person with assault and battery on law enforcement at all if they're undergoing a mental health emergency. There are a number of problems with the bill as it's written, including how does one know that it's a mental health emergency based on the facts that you have at that point. The bill failed, but I expect it or something similar to come back, and it will be something that we as an association should really take a look at and have kind of a nuanced perspective, whether it's a firm no or whether there are circumstances where you as sheriffs may want to advocate for this. Delegate Murphy has a similar bill that also failed. It eliminated the mandatory minimum for assault on law enforcement for people on the autism spectrum who had an intellectual disability or otherwise serious mental illness. And again, the difficulty with knowing that in advance is pretty tricky. That bill also failed, but I expect something similar to continue to pop up. New crimes. I have 4 minutes, 2 minutes. I'll talk really fast. Swatting, I think, is the street language for this first bill. folks who are calling in, and this is a statewide, nationwide problem, calling in, saying there's a bomb threat, law enforcement response, EMS response to a local school or some municipal building, and turns out there's nothing there. So the current law says that if you make a false police report, it's a Class 1 misdemeanor. So that could be used, but the difficulty is that those bomb threats are not being called in to law enforcement, they're being called into a school or to some other person who then calls it into law enforcement. And so there was a little insulation there from prosecution. This bill says if you tell anybody and it turns out that the police respond, then it's a Class 1 misdemeanor. It also has an enhancement if there's damage or injury, it enhances it to a felony. There's that organized retail theft specific bill from Delegate Byron and Senator Stewart, creates a crime to conspire or act in concert to engage in larceny of retail property from a store. So it aggregates over a 90-day period your petty larcenies to make it a felony. $5,000 is the limit. But if you've got a ring of people who are stealing in a 90-day period, it gets over $5,000, it's a felony. You can prosecute it in any jurisdiction if you've got stores all over that they're stealing from, any old jurisdiction, whoever's going to get you the biggest bang for the buck. Delegate McQuinn put in a bill. Her original established a new mandatory minimum for assault of public transportation drivers. What ultimately passed doesn't have that mandatory minimum, but does have a trigger that that person who's assaulted a bus driver or some other public transportation driver can be banned from public transportation, and if they subsequently go on it, that's a trespassing. Delegate Bell put in a bill creating the crime of sexual extortion, which is a unique product of our social media and cell phone era, that if you threatened to disseminate a photo or you threaten to not recall an already disseminated photo of intimate parts of the victim or the victim's family or household member, and you say, have list of sex acts with me, and the sex acts occur, then that is a felony. So you maybe have an attempt if you threaten it and the actual sex act doesn't occur, but you have to have the completed, in order to have the completed crime, you have to have the threat and the completed sex act. Senator McDougal had a bill that creates it's a very helpful scenario of possession of catalytic converters, a presumption that you have stolen it and that you're going to fence it. There are exceptions for scrap metal and for people who can prove that they own the vehicle. So that's I think, potentially a very helpful bill for handling the catalytic converter theft issue. Senator Boysko put in a bill that adds suffocation to the strangulation statute. Currently, it's a bill that requires pressure to the neck. She said that was preventing prosecution of people who were putting a hand over the mouth or a pillow over the face. So this bill extends strangulation to that other type of asphyxiation. And Senator Normand put in a bill that allows a locality to pass an ordinance to allow a chief law enforcement officer to declare a curfew for 24 hours in a time of riot and clear and present danger. So again, your locality has to create the statute in order for it to be there, but that does give you the authority, once the ordinance is there, to declare a 24-hour curfew. There are a number of considerations and qualities that you have to put in your curfew that are in the bill, but that is another tool. New crimes continued. Two failed bills. Delegate Kilgore and Senator McDougal create a new crime of felony murder for distribution. Currently, it's already felony murder to have distribution of a narcotic that results in a death, but they're pretty narrow parameters. Has to be close in time and place. So you basically have to die in the presence of the drug dealer real quickly for that to be prosecuted under the current felony murder statute. This bill allowed it to be distant in time and place. If you buy the drugs, you travel down the road to your own house, and then you take it tomorrow, and then you die, this bill would have allowed prosecution of the drug dealer. That was met with substantial opposition in the Senate, and the bill did not pass. Delegate Les Adams put in 2384, which removed the ban on stopping a vehicle based on the odor of marijuana for the purposes of DUID. That bill also allowed for saliva testing for THC and a variety of other things, and that did not pass. And John is going to talk very briefly about a bill or two.
House Bill 1452 by Delegate Orrock was the Attorney General's bill. We sent it out to the Legislative Committee, and they voted to oppose the bill because what the bill did, it created a police force within the Attorney General's office of 30 law enforcement officers with unlimited authority on what they could investigate or who they could investigate. We thought it was a duplication of what already exists with the state police, and it went way too far. We notified Delegate Orrock, we notified the Attorney General's office. We didn't get much of a response. We got a huge response when Elizabeth stood up at the subcommittee and opposed the bill that stopped it in its tracks. And that's when you all started getting emails from the Attorney General's office. So the Legislative Committee said, oh, we'll take another look at it. They doubled down and said, listen, if the bill does what you want, if you amend the bill to do what you say you want to do, we'll agree to it. That was a pushback, but that's what ended up passing. So you have the 30 officers. They will be law enforcement officers, but they can only investigate Medicaid fraud. So with that, it concludes the program. I want to compliment Elizabeth for helping us in the General Assembly. She was there every day testifying on these complicated bills and helping us out. Did a fantastic job. Thank you so much. I know my staff has already probably gone out and getting everything ready to leave. I just want to say publicly, they did a fantastic job of setting this conference up. We have a new app. We don't have to load boxes and boxes and hundreds and thousands of pounds of paper to bring up. So they worked so hard to get it right, and they did get it right. And I want to compliment it. Not only Elizabeth helped with that, but Megan, Susan, and Lisa. So that concludes the program. We'll see you in Virginia Beach in September, if not sooner.